everyone. I'm Lee Greenfield, the editorial board chair of the Antitrust Law Journal. It's great to be here today for this terrific symposium. I'm very glad to have a chance to talk. At the same time, I think you're glad to hear that I will be very brief. We are very gratified, those of us affiliated with ALJ, to have our latest issues serve as the basis for this symposium. At the same time, I need to say, as did Nick, that neither the journal nor the ABA is a sponsor of today's symposium. A few thanks I wanted to give. First, I want to express my great thanks to REN and GW for putting on a second fantastic annual symposium. Tremendous thanks to the presenters and discussants also. I learned an awful lot today. As always, we owe enormous gratitude to Robbie Robertson, ALJ's executive editor, and Nick Grimmer, our managing editor, as well as the entire ALJ board for everything they do to uphold and exceed the standards of the Antitrust Law Journal. The Antitrust Law Journal is the best antitrust periodical in the world, and for my money, it's one of the best legal journals in the world, period, antitrust or not antitrust. Now, one value that is core to the journal is promoting ongoing efforts to improve antitrust law, both the substance and the process, through thoughtful exchanges of views from the broadest spectrum of antitrust and consumer protection thinkers. We gladly publish all pieces that meet our high standards for acceptance, whatever their viewpoint. The broader and more diverse the viewpoint, the better. We saw this type of exchange in spades today, with participants presenting papers on a really broad range of subjects from a wide range of perspectives, and then engaging in dialogue with discussants, many of whom pushed back pretty hard at some of the points in the papers. And that was great to see. It was great to see the thoughtful presentation from Commissioner Mador as well today. I think that was really valuable. But I think I would be remiss not to comment on some dark clouds we see shadowing antitrust, and frankly, our country more broadly at this moment. This threat is illiberalism that threatens to chill just the sort of free, open, and diverse exchanges that we saw today. We are seeing at least a couple of threats from illiberalism to antitrust. First of all, for the first time in the FTC's history, a president has determined that there should be no involvement in the commission from a minority party. He has simply fired the Democratic commissioners, frankly, I think illegally. Since its founding in 1914, the FTC has functioned as a bipartisan commission. This bipartisan feature has been an essential element of the FTC's success. The bipartisanship promotes full and open determination of cases and optimizes the Commission's crucial role in developing antitrust law and policy. One aspect of this openness are public dissents that we see from FTC commissioners who disagree with the determination of the majority. I will say, for example, that when they were in the minority, Chair Ferguson and Commissioner Holyoke made great contributions to the debate when they disagreed with the majority and raised, very salient issues and really promoted vigorous debate on the cases and issues where they dissented. Until now, presidents of both parties have respected this vital feature of the commission, bipartisanship. I think we're really losing a lot at the FTC if we go to a non-bipartisan model and don't have the kind of bipartisan debate that the FTC has enjoyed for over 100 years up till now. The other real threat we see to antitrust, as well as the legal system more broadly, is that for the first time in our country's history, a president has issued executive orders against law firms, those executive orders purport to prohibit lawyers from the law firm from entering government buildings or even communicating with government officials. In addition, several of these executive orders issued on law firms have threatened law firms' clients who have government contracts. I need to do full disclosure here. My law firm is one of those firms. The president's actions are particularly corrosive for antitrust. One of the great things we have in the U.S. antitrust system is a close and productive working interaction between lawyers advocating for their clients and the antitrust division and FTC enforcers. This benefits the process and produces better outcomes, more accurate outcomes, outcomes that benefit consumers and competition. The right to counsel and freedom of speech to advocate is a bedrock of both our society generally and the antitrust system more narrowly. It must be preserved. In the spirit of extolling the benefits of open and diverse exchanges promoting perfection of antitrust, not that we will ever have a perfect antitrust system, that's an unreachable goal, I do want to share very briefly some things that struck me today as particularly notable about the contributions that the authors of each of the papers that were presented have made. Why were these papers so valuable? Why are they papers that our journal was so pleased to be able to publish? Starting with Eric Posner's paper, his paper brings great lucidity and erudition to a wide range of issues concerning antitrust assessment of labor markets. This is an area where there's been a tremendous amount of confusion that has gotten in the way of effective enforcement. Professor Posner did a great job addressing this confusion and bringing a lot of order and good sense to the analysis of antitrust and labor markets. Keith Clovers and John Jacobson did a really great job explicating and correcting another area of confusion. What I think are misguided concepts of submarkets, which have too often distracted and threatened to distort cogent market definition analysis in antitrust cases. I'm not sure that any notion of submarkets is going to survive their critique, frankly. We then had the paper that Abe Wickelgren presented today that he co-authored with Ian Ayres and Scott Hemphill. This, to me, was an astonishing original and out-of-the-box proposal for what is, frankly, a completely new type of remedy that could address a problem we've had in a lot of mergers. There are a lot of mergers that can bring great efficiencies and benefit consumers, but have a problem in a market that, or multiple markets, that is very difficult to fix under traditional remedy notions. So the notion of finding an economically sensible way to address problems and fix them adequately while allowing mergers with pro-competitive benefits to go forward is a really great and thought-provoking contribution. The folks from White and Case who authored the activist article, this is, again, a really excellent paper. It's accessible and makes a really thoughtful distillation of a convoluted and complex area, the application of the activist case over the last 10 years. And this article benefited from authors who have really been in the trenches and have a great understanding of the real-life issues involved in applying activists. This is another tremendously useful contribution to the literature. Laura Edelson presented her paper that she co-wrote with Reed Showalter. This is a hugely eye-opening examination of an underdeveloped area of antitrust and technology. I, at least, was unaware of analysis and potential theories of competitive harm from dominant firms that hold on to technology and fail to release it, or maybe release it with restrictions and not in an unfeathered way. I think, as John Talladay said, there are very interesting issues of how that might apply in the framework of, what monopolization law actually prohibits, but a really thought-provoking piece that I think opens up very nicely further discussion of just those issues. I also was really struck by how the authors made what I thought was really ingenious use of case studies to illustrate their point, which made the article kind of an article at the intersection of antitrust technology and history, and a really fascinating read. Finally, last but not least, Greg Worden. Greg made a really thought-provoking and lucid contribution to the seemingly endless debate about the appropriate test for evaluating candidate antitrust conduct. I thought the article particularly benefited from really Greg's very unique status. I mean, Greg is a career DOJ economist who's also thought incredibly deeply about antitrust law. I don't know if there's anybody out there who is such an accomplished economist who also is so interested in antitrust law itself. Usually you have legal experts, or you have those who are really focused on the economics and maybe not so expert in the law, but Greg really bridges that divide and had resulted in a great paper that really made some excellent points. So, to summarize, all of these articles are in the proudest tradition of the Antitrust Law Journal, and also in the proudest tradition of free and open dialogue that is so essential to effective development of antitrust law. Thanks very much. It's time to go enjoy cocktail hour.